Magdalena Mole is a young wife and mother from Burbank, Illinois. Last May 5th, she was invited to a party at the home of a friend in a nearby town called Justice. Shortly after midnight, Magdalena went to the street corner outside the apartment complex to catch a taxi. While Magdalena waited for her ride, police officer Carmen Scardine slowly drove by, then stopped in the middle of the street and ordered the young woman to get into his car. When the taxi arrived, Scardine ordered the driver away. Without explaining why he had taken Magdalena into custody, Scardine demanded identification and then called the dispatcher to run her name. He then drove the terrified young woman to a secluded area and sexually assaulted her. Magdalena filed an official complaint, which was upheld by the Justice Police Department. She has filed a lawsuit against the department and the city government, but there is no record that Scardine has been prosecuted or even subjected to official discipline. This is most likely because the officer would claim that the victim had consented to the act. After all, she didn't resist. Of course, if Magdalena had resisted, she most likely would have been prosecuted for resisting arrest or even aggravated assault on a police officer. This assumes, of course, that Scardine didn't simply kill her while taking her into custody. Pittsburgh resident Sarah Smith had an experience very similar to that of Magdalena Mole. One morning several years ago, Sarah was in a minor traffic accident with a man on a motorcycle. Like many other people in difficult financial circumstances, Sarah had let her liability insurance lapse. To make matters worse, her driver's license had expired. So she was probably already in a state of panic when Pittsburgh police officer Adam Squares arrived, and frantic when he pulled her aside. The ensuing conversation left her utterly terrified. Officer Squares told Sarah that, quote, he could make it look like the accident was my fault, or he could give the other driver a ticket for failure to obey signs, she recounted in an interview with the Pittsburgh Post-Gazette. The price of a favorable assessment would take the form of unspecified sexual favors, and Squares quite generously promised that what he would demand of Sarah wouldn't be, quote, as bad as what would happen to me in jail. If Sarah had put up a fight, Squares insisted, she would be arrested for resisting arrest, handcuffed, and then raped in the back seat of the police car. Before the officer could make good on his threat, the situation changed, and he agreed to let the terrified young woman go, but only after gesturing to his gun and warning her that, quote, if you say anything about this, I'll make sure you never walk, talk, or breathe again. That incident took place on July 14, 2008. Sarah reported the assault to the Pittsburgh Police Bureau, as did two other women who had endured nearly identical threats from Squares, one of whom, a woman embroiled in a child custody dispute, was told that she could purchase a favorable recommendation to the child welfare bureaucracy in exchange for oral sex. The uniformed predator was allowed to continue patrolling the streets and collecting his $57,000 annual salary until February 17th of this year, when he was arrested for sexually assaulting a young woman in her home 6 days earlier. The February 11th assault took place in the home of a young woman whose boyfriend was in jail. After asking the victim if she was wearing a wire and turning on the kitchen faucet to conceal any potentially incriminating noises, Squares explained the nature of the transaction. He would help her boyfriend in exchange for sex. After forcing the traumatized woman to service him, the cop cleaned himself up with a paper towel, which he folded and placed in his pocket, perhaps after recalling the lessons taught by Monica Lewinsky's blue dress. Squares was as predictable as he was persistent. Last December, he had paid a similar visit to Melissa Watkins, whose boyfriend was also in jail. She was alone with her young daughter when the cop materialized to proposition her. He locked my front door and everything, he said, so no one could bother us, Melissa told the Post-Gazette. Unzipping his uniform trousers, Squares offered the same arrangement. He would help Melissa's boyfriend in consideration of sexual services. To her considerable credit, Melissa, despite being utterly terrified, refused. There's a man with a badge and a gun in front of you trying to proposition you, she recalled. You don't know which way it's going to go. In his memoir Breaking Rank, a top cop's expose of the dark side of American policing, former Seattle Police Chief Norm Stamper warns that, quote, sexual predation by police officers happens far more often than people in the business are willing to admit. My cautious guess is that about 5% of America's cops are on the prowl for women. In a department the size of Seattle's, that's 63 police officers. In San Diego, where Stamper began his police career, 145. In New York City, 2,000. The average patrol cop makes anywhere from 10 to 20 unsupervised contacts a shift. If he's on the make, chances are a predatory cop will find you, or your wife, your partner, your daughter, your sister, your mother, your friend. The most significant advantage wielded by uniformed predators is not their physical size or even their arsenal. It's their ability to criminalize even the most tentative act of resistance on the part of their potential victims. Recall what Sarah Smith was told during her encounter with Squares. If she fled, she would be arrested for resisting and obstructing. If she fought back, she most likely would have been charged with aggravated assault. This is exactly what happened in the case of a single mother in Milwaukee whose name has not been publicly disclosed, who was raped by Officer Ladmarald Cates when he responded to a 911 call after someone had hurled a brick through the woman's bathroom window. After dismissing the woman's boyfriend on an errand, Cates maneuvered the woman into the bathroom where he forcibly sodomized and raped her. Immediately after the assault, the woman, barefoot and wearing tattered clothing, ran screaming from the house. Kate stormed out of the house and grabbed the victim by the waist, causing her feet to strike his partner. This gave the officers an excuse to arrest the battered and traumatized woman for assaulting an officer. She was taken to jail and held for 12 hours before receiving medical aid. After the hospital visit, she was sent back to jail for 4 days before being released without charges. This was not Cates's first assault, but the department wasn't willing to take disciplinary action of any kind until DNA evidence corroborated the rape victim's account. Instead of prosecuting Cates, the department fired him for idling or loafing on duty. He was convicted of federal civil rights charges on January 15th. Cates is hardly representative of Milwaukee police officers, not because of his casual corruption, but because he was actually punished. The department holds down the number 2 spot in the National Police Brutality Rankings. Cates's victim was handcuffed, jailed, and abused even further, despite the fact that she had done nothing to resist. If she had put up resistance of any kind during the July 2010 encounter, she would most likely be in prison or dead, and Cates probably would have received a commendation for valor. This is because once a sexual predator in uniform initiates force against a mundane, any effort to repel that aggression is treated as a crime. For generations, rape victims were told not to resist because it would only make matters worse. Fortunately, women are no longer expected to submit to sexual assault, but rather to fight back by whatever means are available, unless the assailant is one of the state's costumed enforcers, in which case resisting sexual assault would be a felony. This admission was pried from Gregory J. Babbitt, assistant prosecuting attorney for Michigan's Ottawa County, during the October 4, 2011 oral argument before the state Supreme Court in the case of People v. Moreno. At issue in that case is the question of whether a citizen has a legally protected right to resist an unlawful search or unjustified arrest by a police officer. In a colloquy with Babbitt, Associate Justice Michael Kavanaugh described a scenario in which a woman in police custody was sexually assaulted during a body search. In that situation, Kavanaugh inquired, could the victim be charged under the state's resisting and obstructing statute? Technically, you could do that, Babbitt grudgingly replied, while insisting that, quote, as a prosecutor, I wouldn't do that. Rather than putting up physical resistance and thereby risking criminal prosecution, the victim should simply endure the assault and then file a civil complaint after the fact, Babbitt insisted. That approach, of course, would most likely result in a settlement that protects the offender at the expense of the local tax victim population. If citizens have no right to resist illegal violations of their property and persons by the police, what is left of the Fourth Amendment? One of the judges asked Babbitt. Well, life isn't perfect, Babbitt replied with a sucks-to-be-you shrug. For people of Babbitt's ilk, in any conflict between individual liberty and institutionalized power, it is the former that must yield. Otherwise, mere mundanes, quote, will be able to make the determination as to whether the police officers are acting properly or not, he said, his voice freighted with horror over the prospect. "We can't have individuals making that decision in the heat of the moment." Of course, this is precisely what Babbitt insisted must be done, as long as the individuals in question are emissaries of the state. Ideally, police departments as we know them wouldn't exist. While there is a legitimate role for peace officers, law enforcement agencies are innately tyrannical artifacts incompatible with a free society. Where the use of force is concerned, peace officers should have exactly the same legal standing as any other citizens. In other words, they can employ force, including arrest and detention, for the exclusive purpose of protecting innocent life and private property against criminal aggression. And when they act in violation of the non-aggression principle, they should be liable to exactly the same consequences that would befall any other aggressor. We should work to abolish all statutes criminalizing the common law right to resist arrest. Those who commit actual crimes against persons or property can't really be expected to submit to arrest without a struggle. People who don't commit such offenses shouldn't be required to submit at all.